You are on your way.
I was on my way, madam. I talked to Mr. It has good implications to add his application to pursue an appeal. I would kindly request, in order not to hold this position further, your lordship to...
Even if I made the order, I can't supervise. That's merely formal. You have an objection?
No, we have no objection.
That kills the other petition, Mr. Mohammed. In this, because the Judicial Service Act was enacted to augment Article 171 of the Constitution. The challenge, insofar as I can see, only relates to the nominee by the Public Service Commission under Article 171 2G and the persons appointed under Article 171 2H. The petitioner and those supporting the petition contended that the section should have provided for open, transparent, and merit-based nomination. I have already said that is not. I have said it is true Article 10 provides for transparency and accountability, but it's not in every public appointment that public participation is required, more so where the Constitution is clear and Section 15, subsection 2 of the Judicial Act does not show any inconsistency in as far as nomination of the representative to JSC is concerned. With regard to persons appointed under 2H, that is purely at the discretion of the President, and where the Constitution has conferred such discretion, the court will only interfere if the discretion is not exercised properly. And from the purposive approach, this construction, in my view, resonates well with the whole broader objectives of the Constitution as supported by the Judicial Service Act, which was enacted to give effect to the imperatives of Article 171(2) of the revamped JSC. Consequently, I see no constitutional inconsistency merely because the section failed to provide for an open and transparent manner of appointing members to JSC. So concluding, having considered the petition, the Constitution and the law and the President, I agree with the petitioner to the extent only that the second interest party did not require approval by the National Assembly and that the National Assembly was wrong in vetting and approving him. Regarding the appointment of the third and fourth interest parties, there was no violation of the Constitution, and I am unable to find constitutional validity in Section 115, subsection 2. So the upshot is that the petition succeeded to the extent only, and I make the order declaring a declaration is hereby issued. There is no requirement for approval of the second interest party, the nominee of Public Service Commission, and Article 171 2G of the Constitution, and the approval by the National Assembly made in that regard is of no legal effect. The rest of the petition is, however, dismissed with no order as to costs. Thank you, gentlemen. I will make up